Okay, good afternoon, everyone. Just to introduce myself, I'm Martin Hutchings. I'm part of the Planning Advisory Service, working on the team looking at biodiversity net gain. My colleagues Zain Mohammed and Becky Mobley are with us somewhere this afternoon in the background, making sure everything works. And we are recording the presentation part of this session, but not the Q&A. So we will attempt, if the recording comes out well, to make it available sometime after this session. So welcome everyone. Back in July last year, we launched a suite of legal agreements. One was the condition for biodiversity net gain on-site, off-site agreement and a habitat bank legal agreement. And we've been really pleased by the reception for this suite of documents, and also anecdotally it seems like a lot of councils are using it as the basis for their legal agreements, which was the whole point. So that's really pleasing. We have been collecting feedback along the way, and what we'd like to do in today's session is to take you through some of the changes we've made to the existing suite of documents based on some of that feedback, and to introduce the new phased development template. So that's what we're going to do today. I'm joined by Grace from Dentons. Hello, Grace. Thanks for joining us. Unfortunately, Roy's not with us today. He's billed on the slide there, but yeah, Roy isn't with us today. We've got Grace, and that's great. So just quickly, Dentons are going to take us through updates to existing resources, the new BNG template for phase development, and then I'm going to host a Q&A session. So just a little bit, first of all, on the questions. We have a questions hierarchy. So we've got a BNG hierarchy. I've made a questions hierarchy. Preference today is for live questions, so please put your hand up when the Q&A starts, and we'll take questions from the floor if you like. We have a Slido. You can scan that Slido, or I'm going to put a link in the chat in a second, and you can link to the Slido chat function in there, and ask questions, put questions in there, or you can use the chat function here. But I'm going to give priority to live questions. Whatever things we don't get to, we'll create some sort of output for anything that we don't get to today, or if we run out of time. So I'm going to hand over to Grace. I'm going to stop sharing my screen, Grace, and then allow you to take over.
Great, thanks, Martin. Just want to check, can everyone see that presentation all right?
Yep, can see that.
Perfect. So this is a joint session between Dentons and the Planning Advisory Service. We're just here to support the Planning Advisory Service, and specifically explain a little bit about the BNG templates. So the updates that we made to the existing resources, as well as explain the new phase development condition. So this session will be about an hour. There will be 30 minutes for Q&A at the end. Please do drop questions into the Slido or drop them into chat. Be happy to answer that at the end. By way of introduction, my name is Grace Pino. As Martin said, I'm a member of the Dentons planning team. I will be leading this session and delivering this training. I was originally involved in the creation of the existing BNG templates, and I was responsible for developing the phase condition template for BNG with Roy. I'm a member of the planning team. My colleagues and I support local authorities, habitat banks, and developers with practical and commercially aware solutions for BNG. We've been heavily involved in BNG since its inception. I'm very pleased to be continuing to support all stakeholders with securing BNG. A bit of overview in today's session, because Martin has kind of outlined a bit of the trot through the next hour. We'll be looking at an overview of the existing resources. We'll then consider updates to the existing resources. We'll then look at the new template condition for phase development. Specifically, I will give a bit of overview into the regime for phase BNG, as it's different than non-phased development. I'll introduce the two template options, and then we'll jump to questions at the end. Now, if you attended the previous launch for the existing resources back last year, this slide may look familiar. So the existing resources were drafted to cover 3 scenarios. The first is development delivering BNG on-site. The second scenario is development securing BNG both on-site and off-site at the time consent is granted. Any BNG which will be allocated to another entity will need to be registered, and that means it needs to be secured by planning obligation or conservation covenant. In this second scenario, a developer may want to develop BNG offsite for the purposes of allocating back to itself via the register or to sell onwards to others. This scenario is specifically for developers that have an idea of what their BNG strategy on-site and off-site will be at the time that consent is granted. The habitat banking scenario is just a developer who's carrying out enhancements to land for the purposes of generating BNG to sell onwards. It's completely separated from any kind of planning permission or development. I bring that up because it is worth keeping that in mind when looking at the existing templates and why they've been amended. With regards to the existing templates, you'll see that we have the on-site scenario, which is BNG on-site only, that can be secured by condition. So we have a template condition for BNG for non-phase development. That sits alongside a Section 106 agreement for on-site BNG. That Section 106 agreement just secures a monitoring contribution for monitoring compliance with the proposed conditions for BNG. A local authority should always consider whether it's justified and appropriate to impose a monitoring contribution, but just to give a bit of context into how BNG might be secured, we provided a condition and the Section 106 agreement so that you have a bird's eye view into everything that might be required if navigating that particular scenario. The Section 106 agreement, we've also created an agreement, what we call the offsite legal agreement template. That's for scenario 2, where a developer is securing land pursuant to a condition, so on-site BNG, and also offsite. This looks exactly like the Habitat Bank agreement, but includes a concept of development. And the monitoring contribution covers monitoring compliance with the condition, as well as monitoring compliance with the obligations secured in the deed for the offsite land. So it covers both onsite and offsite. The Habitat Bank agreement, like I said before, is just like the offsite agreement. However, it does not include a concept of development, and the monitoring contribution is only in respect of the Habitat Bank land because it's completely separate from development. I think it's worth just kind of outlining a bit of where we are with the existing resources because it just gives a bit of context into why we updated and what the updates mean. So when considering the updates, it's worth just outlining why we did that. It's helpful to pause here for a moment just to look at that. Firstly, we launched the template resources, or Planning Advisory Service launched the template resources last year. Immediately feedback was received as well as questions for clarification. At every time that was done, we considered whether
Grace, I think you've gone on mute. Sorry.
Hi there.
Hi.
Can you hear me again? Sorry about that.
I can hear you. Yeah, I don't know what happened. That was on ours sometimes.
So hopefully this won't sound a bit like a deja vu, but did we hear anything about this slide on why we updated?
Yes, I think you're about to tell us why we considered whether amendments would be beneficial.
Yeah, so it's really just about a balancing act here where we want to provide as much clarification as possible, make the resources as easy as possible to navigate, but we don't want to be tinkering unnecessarily and providing lots of updates, particularly because you are using them. This is a resource which is being used. We want to make sure that if we're making amendments, they're beneficial. There's a reason for doing so. So we're going to just discuss now a little bit about the amendments to the resources. The one thing that I want to flag before we start is that the previous version of these templates are still legally compliant. So the amendments that have been made are really to provide additional clarification. It's to make them a little bit easier to use in practice. It's also been done to just in response to specific feedback as well. So let's just jump right in. You'll see that the changes to the on-site condition are really just clarification and for readability. So this HMMP works have started bit that you see in blue appeared at the end of this condition. We've put that at the front just to make it easier to read. And there is no requirement now to provide a completion report because that's already provided, there's no requirement to provide notice of completion because there's already a requirement to provide a completion report. So you wouldn't want a developer to provide a notice of completion if you're already receiving a completion report. So it just kind of simplifies the obligations for both sides. We also made changes to the on-site legal agreement, and that may be surprising, particularly because the legal agreement only secures a payment of a monitoring contribution, but we received lots of feedback that local authorities had very different approaches to securing a payment of a monitoring contribution. While we were updating, we decided to provide additional options here to reflect the general positions for securing a maintenance contribution for BNG. We give an example of how that might be secured. It need not be secured in this way. As a reminder, these existing resources and the new one are not intended to be prescriptive. They're just giving an example of how BNG obligations might be dealt with or secured just to provide a bit of a starting point and a bit of a launch pad for local authorities to meet their legal requirements under the regime. The Habitat Bank Agreement has been amended in a number of ways. I've set this out conceptually because I think it's best to kind of look at them by significant points rather than just going line by line with the agreement. The first is changing the concept between land and BNG units. When BNG is allocated to a development, the register allocates land to the developer. Units are not actually allocated. That is commonly how BNG allocation is described. Our Habitat Bank agreement had a hybrid position in the definitions where we specified the area in hectares of land throughout the definitions and also included units. We did that because we thought it was helpful to understand on a one-to-one spatial risk multiplier how many units the agreement is securing. But of course, the unit amount is going to depend on where the development where the development receiving the allocation is located in relation to the Habitat Bank. So you remember the spatial risk multiplier in the metric will discount units that are not within the same national character area or local authority area if it's an area Habitat Bank area habitat unit, or within the same water catchment area if it's a watercourse unit. You could use the previous definition as you want, but we decided it's probably best just to switch everything over by land because appreciating the spatial risk multiplier changes the amount of units, depends where it might be allocated. It was just best to switch over completely to a concept of land only. The second point I'd like to raise is the changes to the biodiversity game plan monitoring contribution. So just like you see on the on-site legal agreement, we've provided 3 options for the payment of that contribution, and they mirror that on-site, those on-site options that we set out. The second point relates to the implementation of the habitat management and monitoring plan. It requires, we now require the implementation of HMMP within 12 months of first allocation instead of 12 months of registration. We've updated the drafting notes as well to explain the requirements to register land. And that reflects DEFRA guidance to require the works to be done at a point in time, which is necessary for these legal agreements to be registered on Natural England's Biodiversity Gain Site Register. The third requirement the third amendment that we looked at was specifically on allocation. So we amended the drafting note for clarity to better explain the restrictions on the operator's ability to allocate unregistered BNG capacity to prevent the possibility of BNG capacity being sold twice. So that is if you're familiar with it, a bit of a double bubble scenario. So nothing's changed on the drafting. It's just the drafting notes to explain that position a little bit better. The next amendment that I'd like to discuss is requiring the registration of the biodiversity gain site as soon as reasonably practicable from completion of the agreement rather than upon first allocation. So a number of reasons for doing this. One, it switches the position so that if you're registering a habitat bank, the habitat bank provider will then go and register the habitat bank on Natural England's register. That gives everyone much more visibility over the number of habitat banks that have been secured in the country, because there's no requirement under law that the registration occur until allocation is made. It is helpful, however, if you want to switch the position to give everyone more visibility about how many units are secured in your jurisdiction. The next amendment is a concept of variation event. So as you'll recall, by looking at that resource, variation event covers a couple scenarios where something might happen on the land, which could change the ability to carry out the HMMP or amend the achievability of the particular biodiversity enhancements. When that happens, it's best to we've amended the template agreement so that if a variation event happens, there's agreement to change the HMMP for unallocated BNG capacity rather than recalculate BNG. That's partly necessary because we've removed the concept of BNG units from the agreement. And really, if something needs to change on the register or a situation arises down the line which needs to be accounted for, the HMMP is really what needs to change, because that is a plan which secures the enhancements and creation, habitat enhancements and creation that will be carried out on land, and will specify how those enhancements and creation, habitat creation, is maintained for 30 years from completion of the works. There's also kind of general amendments to clarity and tidiness, which I'm not going to go through line by line because I think it would bog us down. But everything is kind of explained in that red line document that shows changes. The next resource I'd like to look at is that offsite legal agreement. And as a reminder, that legal agreement really is the Habitat Bank agreement, but includes a concept of development. So all the amendments that I just explained in respect of the Habitat Bank agreement are reflected in the offsite legal agreement template, insofar as they're relevant. So everything is there, is relevant. The monitoring contribution, for example, is the additional options for the monitoring contribution are included in the offsite template. It's just that monitoring contribution will cover the compliance with the condition that is imposed, as well as the Habitat Bank land. That kind of brings us to the next portion of my presentation, which is specifically on phased BNG. We'll look at the template condition, but the first thing that I'd like to do is kind of discuss a bit about the regime. The general BNG regime is contained in Schedule 7A of the Town and Country Planning Act. However, the rules for phase development sit within regulations. So these are the biodiversity gain plan modification and amendment regulations. Throughout my presentation, I'll just refer to them as the modification and amendment regulations, but they apply to outline planning permissions that have approval of reserve matters, where it has the effect of requiring or permitting development to proceed in phases, or any other permissions that are granted that are subject to conditions having that effect. When you work through and read the modification and amendment regulations, it modifies a position in Schedule 7A. So as you kind of look through, you'll see like paragraph 13 of Schedule 7A applies as if, and then it sets out the changes. It is absolutely worth reading through the modification and amendment regulations to ensure that you understand. We've set out in this presentation a plain English explanation of the regime, but we have, for example, assume that we are not dealing with irreplaceable habitat on site. While those rules are not particularly complex, it adds considerable length to deal with that. Irreplaceable habitat itself is also very rare. It's unlikely to arise in practice, which means that if that situation does arise, you're better served going and looking at the regulations to make sure that the legal duties as a local authority can be met, rather than solely relying on this training or what is set out in the template resources. With that in mind, which kind of sounds like a big lawyery caveat, I'd like to just kind of show a little bit about the plain English explanation of how BNG is secured or required to be secured under the regime. So the first is the normal regime has one statutory condition, which is imposed on development. For phase development, you have three. The first condition I'd like to flag is that development may not begin unless a biodiversity gain plan for the overall development has been submitted and approved by the local authority, or a biodiversity gain plan for the overall development has been approved. You've received permission under Section 73, so that's a variation of the conditions, and an earlier biodiversity gain plan for the overall development can be regarded as approved under Section 73, 2C and 2D. Now, if you don't have Section 2C, 73, 2C and 2D to hand, they set out specific rules for how an earlier biodiversity gain plan can be regarded as approved, particularly if you have a 73 permission and the variation of the conditions do not alter the post-development biodiversity gain value. So you're just tweaking a condition that doesn't have a BNG implication, and a biodiversity gain plan has already been approved, it remains approved. There's no need to reapproved overall biodiversity gain plans if your 73 is not changed, or if your new 73 permission is not changing the position. The second statutory condition that I'd just like to explain is in respect of phase biodiversity gain plans. So specifically, a phase biodiversity gain, no phase of a development may begin until a phase biodiversity gain plan has been submitted to and approved by the local authority, or permission has been granted on application under 73 and an earlier phase biodiversity gain plan is regarded as approved under Section 73, 2C and 2D. So it's the same mirroring regime for the overall biodiversity gain plan, the same requirements for a phase biodiversity gain plan. And if you're struggling to understand a little bit about what that phase and overall biodiversity gain plan might entail or what they would include, the modification and amendment regulations do set out what needs to be included in each one of those plans. DEFRA has also published template, overall, and phase biodiversity gain plans. They're very simple and very easy to read through. I would suggest that you open them up to familiarize yourself with a form of outline, overall or phase biodiversity gain plan. Just gives a bit of context into understanding the regime. The last statutory condition I'd like to explain is a condition that relates specifically to 73s. So where permission has been granted on application made under Section 73 of the Town and Country Planning Act, no further development of a phase which has been begun may be carried out pursuant to that permission unless the phase biodiversity gain plan has been submitted to and approved by the local planning authority, or permission has been granted on application made under 73 and an earlier biodiversity gain plan for that phase can be regarded as approved. So to crystallize this point, if there's a 73 permission, this statutory condition restricts further development of a phase which has already been commenced. And that's only if the phase biodiversity gain plan has been approved by the local planning authority or is regarded as approved under Section 73, 2C and 2D. To give a bit of context and illustration into how that works, the overall gain plan shows the strategy for how that phase development is going to secure 10% BNG site-wide. It's indicative. And I think that's something that is worth pausing on and looking at because each phase biodiversity gain plan as it comes forward will specify how much BNG will be secured pursuant to that phase. The phases do not need to secure, if you have 10 phases of development, each phase does not need to secure 1% BNG. Some phases may secure more BNG than others. Some may have a deficit BNG. The overall gain plan is an indicative first shot prior to commencement telling you this is what the strategy is for developing BNG as the development progresses. And then every phase before it commences is going to have to specify what it intends to deliver. The template for the phase biodiversity gain plan that is published by DEFRA specifies, it's got a particular section in it that says if the phase biodiversity gain plan isn't, in accordance with the overall biodiversity gain plan, explain what the differences are. So that gives a bit of informational context. So that at a local authority level, if you're looking at approving the phase biodiversity gain plans as they come forward, you have certainty that you can see kind of what the overall site-wide strategy will be and gives confidence that the site-wide BNG target of 10% will be achieved. The other thing I'd like to just flag is that the phase biodiversity gain plans coming forward can be submitted with reserve matters, or they can be submitted after reserve matter approval. Depending on what the reserve matters are, it's possible that the phase, setting out the strategy for BNG for every phase is not going to be possible until reserve matters are approved. If you think of a truly outline scheme or kind of a vanilla outline scheme where you see consent for development in principle, but you don't know exactly where the buildings are going to be located, that will of course affect the post-development biodiversity value of the site. If, for example, the facade details are not particularly agreed, and there may be green walls or green roofs that might be on the building, but that won't be solidified until reserve matters are approved. Kind of the BNG for every phase is not really known, and that's why the overall biodiversity gain plan is really treated as indicative. It's worth keeping that in mind because the statutory conditions require the submission of these gain plans, but there's nothing in the statute itself that specifies or secures the BNG that's specified in each one of these plans. It rests on conditions or planning obligations to make sure that those that the BNG specified in each one of those phases is actually secured in some way so that a local authority is able to approve those plans when they're submitted. That kind of brings us to the template resource itself. So the statutory condition for phase development, in the same way that this training follows, it assumes no irreplaceable habitat on site. That is just simply to simplify the position. The template resource has 3 parts to it. The first, it explains the statutory conditions in plain English, just in a simple overview, just to summarize what the position is, so that you have that in mind when you're looking to impose other conditions. 2, it includes template conditions in 2 options. And 3, it includes an annex of key requirements in the back. So before looking at the template condition options, I'll just show you the key requirements. This information gives a bit more context in the regime and explains what you might need to keep in mind when looking at the approval of the overall biodiversity gain plan or the phase biodiversity gain plan. One thing that is worth flagging here is that you can't amend the statutory conditions. They are what they are. So the key requirements are really just information to refresh yourself and keep in mind if you are imposing additional conditions in addition to what's outlined in the template resource, or you're thinking about amending it. That kind of brings us to the options that we provided. If you've looked at the phase condition template option already, it should look a little bit familiar. It really is the on-site BNG template resource, but it has, if you'll see, no phase of development shall commence. So it is just very gently amended so that the existing resource that we provided for on-site development works for phase development. And that really is just restricting development until an HMMP or an equivalent plan is produced that kind of sets out what enhancements are going to be carried out on land, and also securing the works and the monitoring and maintenance obligations in the HMMP for 30 years from completion of development. And just like we flagged in the on-site template condition training from last year, completion of development, as kind of set out in this drafting note, is not defined in the statute. Local authorities may wish to agree an informative specifying the meeting of completion to development. So what does that mean for every phase? Because the obligations for maintenance will trigger from completion of development, however that be defined. The second option is a bit different. For large phase development, you might have a need for strategic site-wide control. If you can imagine a large development where you might have, landscape or open space, it may interact maybe with drainage or SUDs. You might want to have a strategic controlling document where BNG might be affected by the principles of those documents, but it's not the sole purpose of that controlling document. So what we've kind of set out here is an example where you might want to, you may impose, for example, an outline landscape ecological management plan that has the principles that could affect BNG across the site. And then every phase coming forward sits within that outline landscape ecological management plan. So BNG is one of the aspects of that, the OLEMP, but it is not the only aspect. And you can see that, conditions like that might be prudent if you had a development that was going to be carried out over a long period of time, where BNG or ecological or green landscaping features might interact with other elements that are secured on the land. So that kind of pins everything all in one place, and then every phase coming forward is sitting under that umbrella. And if you look at the existing templates for, that have already existed. We've got this Section 106 agreement for securing an on-site, securing a contribution, monitoring contribution for BNG. Securing a monitoring contribution may be justified and appropriate for phase development. We've opted not to draft a fresh Section 106 agreement just to secure a phased monitoring contribution. We think the principle is already kind of established there and wouldn't be a good use of resource, but the existing options that are set out in the updated Section 106 agreement for on-site BNG could be very easily adapted to tailor a phased payment of a monitoring contribution, or if you wanted to, secure all of the BNG upfront, or you can look to the existing triggers within that Section 106 agreement and use that template to modify your securing your phased BNG contribution. And I think I've gone through. If we could just, I think we've got some time for some questions. And I think I'll just kind of pause there for a moment.
Okay, thank you,